bonjour à tous. Il me fait grand plaisir de vous accueillir à cette assemblée locale sur le projet de loi C7, une loi qui modifie le code criminel et plus spécifiquement les éléments liés à l'aide médicale à mourir. Je me présente, Peter Schiefke, votre député fédéral pour Vaudreuil-Soulanges. Ce dernier a reçu la sanction royale le 17 mars dernier et après presque 4 ans de révision et d'études parlementaires, de nombreux cas apportés à la Cour suprême du Canada, ainsi qu'un autre projet de loi précédent, nous étions fiers de présenter un projet de loi qui répondait à la décision de Truchon de septembre 2019 de la Cour supérieure du Québec et au consensus de la société émergente sur des questions spécifiques liées à l'aide médicale à mourir. Cette discussion aujourd'hui va se faire en français et en anglais. Et si vous n'avez pas eu la chance de faire déjà, je vous encourage de soumettre vos questions dans la langue officielle de votre choix. Et vous pouvez le faire en utilisant la section des questions et réponses en bas de votre écran. Thanks everybody for joining us today for this very important discussion on a topic that is personal for so many. Today's discussion with the Minister of Justice, the Honorable David Lametti, will occur in French and in English. And if you would like to submit your questions and haven't done so as of yet, please submit them using the Q&A feature at the bottom of your screen in the official language of your choice. Comme plusieurs d'entre vous le savent, l'aide médicale à mourir est un sujet délicat et complexe. Les mesures mises de l'avant par cette législation sont le résultat des consultations extensives avec 300 000 Canadiens et Canadiennes et plus d'une centaine d'experts et de parties prenantes. Ainsi, j'espère qu'aujourd'hui, vous quitterez cette rencontre avec une plus grande compréhension de la structure qui a amené à cette loi, ainsi que des amendements apportés. This is a piece of legislation that is, in fact, many years in the making and was something that was a necessity and requirement for the Parliament of Canada to address. Many people don't know the history of the legislation, and the minister will be speaking a bit to it, but just kind of a brief on it. In February 2015, the Supreme Court of Canada ruled in Carter versus Canada that the parts of the criminal code would need to be changed to satisfy the Canadian Charter of Rights and Freedoms, and the parts that prohibited medical assistance in dying would no longer be valid. The Supreme Court gave the Government of Canada until June 6, 2016 to create a new law. And in June 2016, the Parliament of Canada passed federal legislation that allows eligible Canadian adults to request medical assistance in dying. The minister, as I said, will be speaking to it. And once again, we'll be touching upon the actions that we took as a result of those court rulings. Now that the bill is passed in its revised form, the Government of Canada is working with provinces and territories and with healthcare professionals to ensure eligible Canadians will be able to request medical assistance in dying according to the new law, and that the appropriate protections are indeed in place. Donc aujourd'hui, on a la chance de discuter et d'accueillir avec notre ministre de la Justice du Canada, l'honorable David Lametti, qui a présenté et géré le projet de loi C7. Il représente le comté de la salle Verdun depuis 2015 et a beaucoup d'expérience en loi et politique. Et juste de l'avant de se présenter comme candidat fédéral dans les élections en 2015, il a été professeur de loi à l'Université de McGill. Mr. Lametti, Minister Lametti, it is a privilege to have you joining us here in Vaudreuil-Soulanges. C'est un plaisir de vous accueillir cet après-midi pour parler directement aux citoyens et citoyennes de Vaudreuil-Soulanges. Et sans plus tarder, je vous passe la parole.
Merci, Peter. Merci à vous tous d'être ici aujourd'hui avec nous et merci à l'équipe de Peter de d'avoir organisé cette rencontre. Alors, j'aimerais vous donner un peu d'histoire, si vous voulez, avant de répondre à vos questions. Ce qu'on a fait avec les projets de loi fédéraux, c'est de répondre à une décision de la Cour suprême dans l'affaire Carter en 2015, comme Peter vient de souligner. Il y avait une autre décision il y a 20 ans à peu près, l'affaire Rodriguez, où la Cour suprême a tranché contre l'aide médicale à mourir, une décision 5-4 de la Cour suprême. Donc, c'était serré à l'époque. Et vous voyez une photo derrière moi, le juge Peter Corey, pour qui j'ai travaillé à la Cour suprême en tant que clerc ou auxiliaire juridique. Il était l'un des juges dissidents à cette époque. Selon le code criminel, c'est un acte criminel de aider quelqu'un à se suicider. Et donc, ce qu'on fait au fédéral, on donne des exceptions dans certains cas pour justement aider d'autres personnes à terminer leur vie, à mettre fin à leur vie. Donc, ce qu'on appelle l'aide médicale à mourir. Et donc, c'est une exception, c'est la raison pour laquelle c'est fédéral. C'est une exception au code criminel et donc on est en train de définir les exceptions. La Cour suprême en 2015, dans l'affaire Carter, nous a dit que la capacité de choisir de mourir, c'était un droit fondamental, selon la charte, l'article 7 de la charte et d'une certaine mesure, l'article 15 de la charte canadienne. Et donc, on a dû réagir à cette décision en modifiant le code criminel. Évidemment, les provinces, Québec, ont un rôle à jouer parce que le Québec, comme compétence, doit fournir des services médicaux. Donc, la santé tombe sur les compétences du Québec et donc les provinces ont un rôle à jouer pour l'encadrement du processus en pratique après que le fédéral définit les normes en modifiant le code criminel. So what we did in 2016, in the first piece of legislation brought forth by my predecessor in the Justice Department and the Minister of Health at the time, was to create a number of categories that allowed for MAID to be chosen. And in general, they fell into what we call end-of-life regimes, fin de vie. So people who had incurable illnesses, usually cancer, sadly, or other forms of illness, whose death was reasonably foreseeable. So a death that was going to happen because of the natural progression of the illness or the condition in the short or even the medium term. And it began, therefore, in 2016 as a practice that was very well received across Canada. I can tell you that the number of stories that we have heard from the families of people who have chosen MAID, as well as from health practitioners, doctors, and nurse practitioners who offer MAID as one of the palliative care services or services that they provide. The stories are very moving and they're very positive about people not having to suffer more than they wanted to suffer, and being able to choose to die with their families around them, and they felt with dignity. So very popular. We knew at the time, and I frankly thought this was the case at the time because I voted against the law at the time because I thought it was unconstitutional. I thought it didn't go far enough. And I thought there was a category of incurable illnesses and conditions that in which death wasn't reasonably foreseeable in the short term, or even reasonably foreseeable at all. And that according to the Supreme Court's decision in Carter, these persons had a right to opt for MAID because that's the way it was framed in Carter. And so sadly, I proved to be right in 2019 in a case that was brought in Quebec by Nicole Gladu et Jean Touchon. Et la Cour supérieure du Québec a décidé que le critère d'une mort raisonnablement prévisible était contre la charte. Et donc, ils nous ont donné une période de temps pour enlever ce critère. En enlevant ce critère, il fallait regarder aussi l'équilibre parce qu'on avait mis des sauvegardes dans l'encadrement de la loi originale, justement pour protéger les personnes handicapées et d'autres, pour s'assurer que le choix était libre et que personne pourraient pas être forcés de subir l'aide médicale à mourir, c'est encore le cas. Mais il fallait regarder le tout de nouveau. Et c'est ce qu'on a fait. Et puis, on a eu une extension à 3 reprises du délai à cause des élections, à cause de la COVID et à cause d'autres facteurs politiques, le Parti conservateur. Mais finalement, on a promulgué la loi, ce qu'on a actuellement, où on a effectivement 2 régimes maintenant. Donc, on a le régime original, fin de vie, avec les critères. Et là, on a modifié quelques critères qu'après l'expérience des 4 premières années, ne faisaient pas ce qu'ils étaient visés à faire. Donc, c'était des critères inutiles et qui ne protégeaient personne et qui a prolongé la souffrance des gens. Donc, on a modifié très peu, mais modifié les critères existants. Et puis, on a ajouté un deuxième régime pour les personnes non en fin de vie, avec des sauvegardes plus élevées, justement pour répondre aux craintes des personnes handicapées surtout, et de avoir une période adéquate, une période diagnostique adéquate, ainsi que un critère deux autres critères. Donc, un critère d'avoir un expert dans la condition pour fournir une certaine expertise dans l'étape diagnostique. Et puis, une discussion nécessaire des options pour vivre. Si la personne, quels étaient les appuis possibles pour quelqu'un dans cette situation-là de connaître les options, les appuis des 2 niveaux de gouvernement, etc. And so we added those additional safeguards because this was a longer period of time. The third thing we did in the previous regime, in the end-of-life regime, was add what is called Audrey Parker's Amendment, after the story of a young woman who had terminal cancer, and the cancer was affecting her brain, and she felt she would lose under that first regime, she would lose the capacity to make a final decision again. She wanted to spend another Christmas with her family, but because she was fearful that she would lose that final capacity, she opted for MAID early. So what we are doing in that first regime is that if you are at the end of life and you have fulfilled all the criteria for MAID and you've been approved for MAID, you can set a date with your healthcare provider. If by chance you lose consciousness, then the healthcare provider will be able to go through and fulfill your wishes. That means less suffering for people because people weren't taking their medication, their pain medication, because they wanted to be able to make that final decision again. By allowing the decision to be made earlier on, again, this is only for people who have been found eligible for MAID. They are able to do that. Again, it's a very short-term thing, but so far it is something that has been received very positively in the community. What's left? Well, in 2016, we noted that there were a number of sticky issues that we had yet to reflect upon. First was mental illness. Could mental illness be the sole criterion for seeking MAID? At the time, we weren't ready, although mental illness could be a co-criterion with other medical conditions, and that is still the case. So mental illness, the question of mature minors, what does one do with a 17-year-old who, by all accounts, has let's say a terminal form of cancer and is capable of otherwise making decisions? The Quebec Civil Code, it's the age of 14. So what does one do with mature minors? And finally, the issue of advanced requests. Two sort of classic cases. D'abord, quand on a une maladie avec une progression connue, donc avec Alzheimer's ou Huntington's, on a une idée des étapes. serait-il une bonne chose de donner le pouvoir à quelqu'un de dire, OK, quand j'arrive à une étape où je ne suis plus en mesure de reconnaître mes enfants ou ma femme, mon mari, j'aimerais que mon fils, ma femme, mon mari prennent la décision de aller chercher aide médicale à mourir dans mon cas. Est-ce qu'on devrait donner un tel pouvoir? Je peux vous dire que beaucoup de Canadiens et Canadiennes sont très en faveur. On a fait des consultations en personne, en ligne. Je peux vous dire que 70% des Canadiens et des Canadiennes sont en faveur et c'est encore plus élevé au Québec. Il y a une autre forme d'une demande par anticipation où quelqu'un va devant son notaire, et évidemment, les notaires sont pour. Quelqu'un va devant son notaire pour rédiger un acte notarial en disant, si jamais je perds la capacité de reconnaître ma famille, j'aimerais qu'un comité où ma fille, ma femme, mon fils prennent la décision de chercher l'aide médicale à mourir. Donc, c'est plutôt général, sans une condition préalable, sans une condition connue. Donc, ça, c'est encore plus large. Et donc, ça aussi, c'est une question qu'il fallait aborder. On avait dit en 2016 qu'on allait le faire dans 5 ans. On avait commissionné des études, des universitaires et des experts dans les 3 cas. On a reçu les rapports. Et ça faisait encore partie, et ça fait encore partie du plan du gouvernement avec une seule modification. Devant le Sénat, le projet de loi qu'on a eu, on avait dit qu'on voulait exclure les maladies mentales comme seule condition. Et le Sénat a modifié le projet de loi pour dire qu'il faut le faire en 2 ans. So we will have to, at the very least, determine that question of the criteria for mental illness as the sole criteria, how it will be done within a period of 2 years. In order to get all of this done, so the review of the whole and those 3 general issues that I talked to you about, as well as implementing mental illness as the sole criterion, we have constituted 2 commissions. So one is a committee of experts in the field of mental illness that hopefully will be named soon. We've given them a period of 1 year to come up with best practices and actually drafting guidelines that will serve to guide parliamentarians in order to get this done before the 2-year sunset. And then we have also commissioned a larger committee of parliamentarians, 10 from the House of Commons and 5 from the Senate, to look at not only mental illness, but also advanced requests, also the question of mature minors, as well as looking at larger questions of palliative care and how to protect and safeguard the disabled. And that committee has been named already. They're going to meet, they have their first meeting in the next couple of weeks. And they too will have to meet in a year, and then parliamentarians will have another year in order to frame the whole thing in legislation where that might deem to be necessary, at the very least in the case of mental illness. So that's where we are. There's a lot of work to be done. There's still a lot of time for input on the part of citizens, and so your initiative today to learn more about the current landscape for MAID is very opportune. And I would just repeat, we are reacting to a Supreme Court of Canada decision. We were originally, and then we reacted to a Superior Court decision which asked us to modify the original regime. We've done that. Now we're moving further with, I think, the will of Canadian people. We're moving in sync with Canadian people, step by step. It's an evolution, not a revolution. And we will continue to listen carefully to what Canadians have to say. We'll continue to listen carefully to what experts have to say as we move forward. Thank you. Merci.
Merci beaucoup, Monsieur le ministre, très apprécié. On avait des questions qui ont été soumises en avance par des concitoyens de Vaudreuil-Soulanges. Et on va commencer, Monsieur le ministre, avec une question de Luc Labelle. Et la question est la suivante. Pourquoi refuser aux personnes se sachant atteintes Alzheimer, de démence ou d'un cancer incurable le droit de demander à l'avance l'euthanasie?
D'abord, on le fait en partie. Donc, si la personne tombe dans le régime fin de vie, il y a la possibilité dans le cas, disons, d'Audrey Parker. Mais pour les déterminations ou les décisions dans un avenir qui n'est pas proche, on savait dès le début que c'était difficile. Donc, comme je viens d'expliquer, il y a des cas différents. Il y a le cas des maladies connues avec une progression connue, avec des étapes connues. Il y a un pouvoir plus général. Est-ce qu'on devrait se limiter à l'un cas ou l'autre? Donc, ce sont des questions éthiques très difficiles. Est-ce qu'on devrait employer un comité des personnes? Est-ce qu'on devrait employer les faits? Est-ce qu'on peut désigner des membres de la famille? Il y a des questions très, très difficiles et on va dans cette direction. La population canadienne voudrait qu'on procède dans cette direction. Il faut le faire avec attention et prudence, et c'est ce qu'on est en train de faire. On va dans cette direction, mais on ne pouvait pas le faire dans les délais imposés par la Cour supérieure, donc il fallait répondre absolument à la Cour supérieure, et puis on continue avec le plan original, c'est d'étudier ces questions comme il le faut.
Merci beaucoup, Monsieur le Ministre, et merci, Luc, pour votre question. The next question, Minister, comes from Francine Turgeon, and her question is, what safeguards will there be if someone decides to change their mind? What about those with mental health issues? There are other medical services available that they need to be protected. Who will be witnessing the decision-making process and ensuring there are oversights?
Thank you. There are a lot of questions in there. First of all, you can always change your mind. And it is currently the case that at any point you withdraw your consent, it's over. The process immediately stops. So you can always change your mind. I suppose the only situation where you can't is in the Audrey Parker scenario where you've given your consent and you lose consciousness. But I think it's fair to say that in those circumstances, it's hard to believe one would have changed their mind anyway. But as long as one is capable and conscious, one can change their mind, and that's built into the law. I would also add that healthcare practitioners are not in any way forced to participate in this process. So there is freedom of conscience for healthcare practitioners as well. We understand this is a difficult issue. Mental illness is something that is going to be studied very quickly. It is an illness. It is a serious illness. It is a serious condition. We have come to understand more about it in recent years. We're beginning to invest more in it, beginning to understand it better. I can't predict what will be the result of the work of either the expert committee or the parliamentary committee, but I would strongly expect that it will contain a number of very specific safeguards with respect to the diagnosis and the treatment of mental illness before MAID is allowed as an option. If I were a betting person, which I'm not, that's what I would bet on. That there will be very strong safeguards put into place that are specific to the expertise and the best current thinking with respect to mental illness. And of course, there too, one can always change one's mind. The third part of the question, Peter, I believe was about safeguards more generally. Do you mind just reading that part back?
Sure. It was there are other medical services available that need to be considered to protect people. Who will be witnessing the decision-making process? So what kind of oversights are in place?
Yeah. Well, first of all, yes, that first part of that question is true. We do need to invest with the provinces in palliative care. and in making and investing in making the lives of disabled people and others more livable. In order for this to be a choice, in order for MAID to be a choice, there needs to be a choice. And so one needs to be able to if one chooses to live, they have to be able to live with dignity. And if they choose to die, they have to be able to die with dignity. And so dignity is the criterion, and we need to work on the living part as well. With respect to who, as I said, we work on the criminal law part. And yes, Manon, this does apply in Quebec, because this is now legally framed in the criminal code. And so somebody will be able to demand this service as part of their rights as articulated in the criminal code. So Quebec will bring their system in line, and we've worked with Quebec all the way through. But it is largely up to the provinces to do the administration. So and a lot of the oversight will be done by the provinces in terms of putting in the regimes that will assure that not just the criminal law standard is met, but also the provincial health standards are met as well.
Merci, Monsieur le ministre, d'avoir répondu à la question de Manon Cyr concernant la situation au Québec. La prochaine question vient de Christiane Legault. Et la question est la suivante. Faut-il avoir signé des papiers lorsque nous sommes bien et lucides pour obtenir l'aide médicale à mourir lorsque nous serons malades et prêts à mourir?
Alors, oui, il faut d'abord, il faut avoir la capacité. Et il y a des critères dans les deux cas. Donc, cas fin de vie, cas non fin de vie, les deux sont un peu différents. C'est un peu plus exigeant dans le cas non fin de vie. Et donc, il y a des prérequis pour des témoins pour avoir eu des discussions éclaircies, etc. Donc, dans les deux cas, c'est bien encadré. Pour l'instant, et il faut évidemment avoir la capacité de prendre une telle décision. Ça fait partie de n'importe quel acte juridique. Donc, il faut avoir la capacité de donner le consentement. Et pour l'instant, les demandes par anticipation, donc les demandes dans un avenir pas connu, ne sont pas possibles, mais nous sommes en train de l'étudier et espérons qu'on arrive à une solution d'ici 2 ans.
Merci beaucoup encore, Monsieur le ministre. J'ai deux questions qui sont à peu près la même. On va commencer. We'll start with Sandra Seto, who asks a very similar question to one that was submitted by Angela Cyr. And Minister, I'll read them both to you. Very important subject. Thank you for your hard work. You say that healthcare professionals are not forced to do this. So who is going to do this, i.e. hospital settings or when we're at home? Thank you for answering my question. And that coincides with the question that we received from Angela Cyr, who says, how will medical doctors be protected for their own conscience and views? This seems to be more about a patient's choice, but I'm concerned for medical personnel who feel stressed to do something that may go against their conscience. Could you elaborate on that process?
Thank you for both of those questions. It is clear in the Act that no medical practitioner is forced to participate in MAID. So if there's a conscientious reason, a religious reason, or other ethical reason why one doesn't want to participate in the MAID process, one isn't forced. And you're right, I believe it was Angela, you're right to say that this is a patient-oriented bill. It is, but that safeguard does exist for practitioners. So far, we haven't seen major systemic challenges with the provision of the services, with the exception of the North, where sometimes health services are tough and we need to work on that. But so far, there hasn't been a shortage of medical practitioners who are willing to participate in MAID. So with respect to the first question, it hasn't been a problem. As I said, the medical practitioners that I've spoken to, including some who were opposed in 2016, who are no longer opposed and who now participate because they've seen that it can be a positive, uplifting experience. Some provinces have had challenges with facilities run by religious institutions, and that's a stickier issue for the province to decide if there are alternatives. If there are alternatives or alternative sites where MAID could be had at alternative hospitals or alternative care facilities. And that's a tough one. There were a couple of horror stories out of British Columbia where persons were basically left out front, on a gurney to be picked up and brought to another institution because the institution in which they were in didn't want to participate. But those are the exception, and those are situations that the provinces have to manage, and for the most part, they are making sure that MAID is available to their populations.
Thank you, Minister. Merci, Monsieur le Ministre. On va aller avec une question de Monsieur Julien Bédard, qui habite à Vaudreuil-Soulanges. Il voulait savoir, Monsieur le Ministre, pourquoi on ne peut pas donner de consentement préalable à l'aide médicale à mourir?
Comme j'ai expliqué, c'est une question difficile. On doit encadrer la question. On a donné un consentement préalable dans le cas d'Audrey Parker, donc le cas où les autres critères sont remplis, où la fin est prévisible et une personne peut établir une date avec leur médecin. Donc, on l'a fait dans ce cas. Les autres cas, ça ressemble plus à une situation d'une demande par anticipation. Et donc, il faut étudier encore comment l'encadrer. Il y a plusieurs défis. On va dans cette direction. C'est clair que la grande majorité de la population est d'accord d'une certaine manière. Il faut juste déterminer la manière et l'encadrement.
Thank you, Minister, and thank you for that question. The next question is from Mr. Josh Brake from St. Lazare. And his question is, terminology is important. Dying, killing, and suicide are not the same thing. Bill C7 disregards the terms killing and suicide and instead has chosen to employ the word dying to describe the action taking place. Could you please, Minister, provide a reason explaining why this is the case? Thank you.
Well, I think the language being used is reflective of the fact that we want to respect the dignity of people who are choosing to seek MAID. As I said in the beginning in the presentation, that in terms of the criminal code, these provisions are an exception to criminal code prohibition from helping someone else commit suicide. And it is often called assisted suicide in a number of different contexts. The term medical assistance in dying is more accurate in that sense, because in particular, the vast majority of cases are in that end of life scenario. It is someone who has sadly terminal cancer or some other condition, so the end is near, and it really is just assisting them in dying in the manner and with the dignity that they wish to have. But I agree with you that words are important, and I do recognize that, and I think that in this case the words chosen not only add dignity but reflect the reality of the process.
Thank you once again, Minister. I have another question here that actually coincides. There's one that was submitted in advance by John David from Rigo, and another one that was submitted by René Masson that was just submitted online. And I'll read them both to you, Minister, because they kind of connect with one another. The first question from John David is, why was Bill C7 amended to allow for mental illness to become, in 2 years, valid grounds for MAID? And are you concerned that this amendment will undermine suicide prevention efforts? And that was the first question. And then there was another question that was just posted online by Renee that speaks to a loved one who went through a very difficult time and decided not to use or seek medical assistance in dying. And her question is, my question is, how does Bill C7 not encourage people like my loved one to opt for sterilized suicide in quotations? It's at the hardest point that people like her need to be told to stay. How does Bill C7 offer hope and inspiration to those who need it most?
Well, thank you for those questions. These are really difficult issues and difficult questions. Mental illness is something that we as a society are really only beginning to understand. And it is true that in many cases, people heal. And so for the time being, C7 doesn't do anything, at least not for a period of 2 years. And with respect to the process, I'll get back to that in a second. So as I mentioned, we have a 2-year window to elaborate an appropriate set of criteria so that hopefully, Renee, we only allow medical assistance in dying where mental illness is the sole criterion. In those cases where I hate to put it this way, but where the sort of medical hope is lost, and always respecting the autonomy of the individual. It may also be that there may be a long process that a person simply doesn't want to go to. So there's a very, very difficult and challenging balance between what we know, medical science, and between respecting the autonomy of the individual who is suffering horribly. And like my motivation in all this is to reduce suffering and to help people reduce suffering. I'm just going to go sideways for a second, Peter, and tell the story of my mother, who my mother was a devout Catholic and died of a really horrible form of dementia. Now, we had this discussion 10 years prior to her death, about 50. She died about 5 years ago. She died in 2016 of all times, but as we were going through these other considerations. But so I knew what her wishes were, her wishes were to follow the doctrines of the church, and we're both relatively knowledgeable Catholics, both my mother and I, and so we had that discussion, and we certainly respected those wishes. But having gone through that with my mother, I want to make sure that other people had a choice to do people with different ethical structures, and so that motivated me. With respect to the Senate and C7, so back to the original answers. Sorry for that excursion. We had always thought that we would get to mental illness in that series of reforms that were always planned from the beginning in 2016, along with mature minors and along with advanced requests. There was a feeling in the Senate, and there was some expertise in the Senate, particularly Senator Stan Kutcher, who was one of the leading experts on this. He was a mental health practitioner before being appointed to the Senate, and was a leading Canadian scholar in the area. And he felt certain that, first of all, we needed to treat mental illness the same as we treated any other illness. And he felt quite certain that there was an emerging consensus that we could find a just and equitable and sensitive way of moving forward, and frankly was threatening to undermine the whole bill in the Senate. And we had some legal opinions. I didn't share it personally as a jurist, but there were other leading legal opinions out there that said, if you treat mental illness as a sole criterion differently, this will be found unconstitutional by the courts. And so, again, my whole goal in this was to reduce people's suffering. I didn't want to have more people. One of the arguments I made in 2016 was, we're going to force people to go to court to challenge this, and that's what Jean Truchon did, and Nicole Gladu, and that was hard, and I didn't want this to happen again. And so I compromised with the Senate. We created their amendment was a 2-year sunset clause, which we think will give our experts and our parliamentarians sufficient time to elaborate a safe set of criteria for mental illness, understanding its complexity, but also recognizing its seriousness and recognizing that mental illness is an illness to be treated on the same footing legally as other illnesses.
Thank you, Minister. And I very much appreciated you sharing your personal anecdote on this, because I think it reinforces just how personal this issue is. And at the end of the day, these are personal decisions that will be taken by Canadians and their families. And so I don't think any apologies were needed there. Perhaps we can go with 2 more questions, Minister, just respective of your time. I have a question here that comes from Pierre Leslie, and it says, greetings, Honorable Minister David Lametti. Are you acquainted with the Swiss model? My experience was quite emotional, an interesting one, and I have become quite positive about that experience. And I'm wondering if you could perhaps speak to what other countries are doing and how that relates to the model that was put in place here in Canada.
Thank you, Pierre, for that question. We looked at other models, Switzerland, one of them, the Benelux countries as well. So the Netherlands, Luxembourg, and Belgium, as well as a number of increasing number of American states. We are in some ways at the cutting edge. In others, we're not quite as far along, but we do now situate ourselves. We do now situate ourselves in that range of countries, the Benelux countries and Switzerland. When we get to a point where we have a framework for mental illness, if we get to a point where we have we have a more rigorous, perhaps a more rigorous possibility for advanced requests, then we may very well be out at the forefront. There is, there have been cases from Europe. I'm not thinking Switzerland right now, but I'm thinking more the Netherlands, where there were it was difficult, where someone did want MAID and then had Alzheimer's and then lost a certain part of their capacities. And so these are often cited as counterexamples. So we're careful. We looked at other countries. We put together a model that respected our charter and that we think respects Canadian values. But we were informed by what was happening in other parts of the world.
Thank you, Minister, et merci pour la question encore. J'ai une question qui vient juste d'être soumise en ligne, puis une autre question qui a été soumise en avance. Je vais commencer avec la question qui a été soumise en avance par Laurel. Laurel's question, Minister, is, once the sunset clause has passed, and if there's been no acceptable stand on assisted suicide for the mentally ill, what steps can be taken to renew efforts in this regard?
Laurel should know better than to ask me a hypothetical question. Is my short answer, and I can hear her laughing out loud all the way from Concordia, or from her house. Look, if it's a sunset clause, so if we don't make it, then mental illness becomes possible to seek MAID with mental illness as the sole criterion. Again, you wouldn't be able to just walk in off the street. You would have to fit into one of the 2 existing scenarios, but it wouldn't have the potentially more robust safeguards that we ought to have with respect to mental illness. So it would probably fall in the non-end of life regime, and there are certain, obviously, categories and criteria for evaluation would be done on a mental illness standard, but it may not be as precise or as pointed as we would like it to be as legislators. I firmly hope we don't get there, but it still means you can't just walk in off the street. You still have to fulfill the Carter criteria, etc. and so I'm confident that we're going to get there, and I'm going to push my colleagues to make sure we do get there. If I continue, I'd love to continue in this role, and I hope to be someone who's still participating and pushing this process forward.
Thank you, Minister. And we'll end off with one question by Pat, who says, how far in advance can this be done with reference to, when the time comes, ensuring your loved ones have access to this? Is it done with a notary in the form of a mandate? I am thinking of someone with a diagnosis of Parkinson's as well as dementia. Thank you so much for a most informative afternoon. And we'll end off with that question, Minister.
Pat, for the time being, that if I've read the case correctly, is probably not yet possible. That's something that we are going to study. Those kinds of advanced requests, something that we have now committed ourselves to study within the next 2 years with a parliamentary committee. As I said, there's a large degree of support for it. You may end up having to go in front of a notary, and it may be limited to cases like Parkinson's that have a known progression, a known diagnosis, or Lewy body dementia. But that's not possible yet. It is supported by the vast majority of Canadians. We will continue to move forward in that regard, and hopefully we get there. The only exception so far is the advance consent in a case, and it's terminal cancer, and it is where we are now. So, Peter, there are some questions from Suzanne Lefebvre, and I would actually like to answer them. I'm a practicing Catholic and I'm a believer, but I understand full well, je comprends très bien que je suis une personne publique, un élu dans la société humaine. Et je peux vous citer, si vous voulez, la distinction citée par Saint-Augustin, city of God, city of man. I believe in the city of God, I aspire for the city of God, but I live and work in the city of man. On a des chartes, on a d'autres documents qui encadrent notre société. On donne une autonomie aux personnes de prendre les choix personnels pour encadrer leur vie. Et je suis pour de tels choix, même si je ne suis pas pour certains aspects des choses choisies par des personnes particulières. Donc, je favorise l'autonomie dans notre société, c'est une valeur. J'appuie la charte des droits de la personne, soit la charte québécoise, soit la charte canadienne, où de telles valeurs sont encadrées. Je garde ma propre foi et mes propres croyances, mais je dois agir pour la population qui m'a élu. Et donc, je suis toujours en dialogue avec eux, justement pour favoriser et faire progresser notre société.
Mais merci beaucoup, Monsieur le ministre. C'était vraiment un privilège et un honneur de vous accueillir ici dans la communauté de Vaudreuil-Soulanges. Merci d'avoir répondu aux questions mises de l'avant et posées par des citoyens dans ma communauté. I just want to thank you, Minister, for having given us an hour of your time to address an issue that is so personal for so many of us. I very much, on behalf of all the members of our community of Vaudreuil-Soulanges, want to thank you for that. Juste un petit message à la fin. Si vous avez soumis une question, puis on n'a pas eu la chance de répondre à votre question, on va essayer de le faire super. If you put forward a question either in advance or a question that you had put forward during this 1 hour long video conference, and we weren't able to get to it, my team and I, working with the minister's team, will try and get you a response to that as soon as possible. Donc, un gros merci encore, Monsieur le ministre. Un gros merci à tout le monde qui ont pris une partie de leur après-midi d'être avec nous pour parler de l'aide médicale à mourir. Et je vous souhaite une bonne après-midi. Have a wonderful afternoon, everyone. Merci.